5 seconds to go. Start. The proclamation shall be published as follows. It shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. It shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides, or to some conspicuous place of such town or village. A copy thereof shall be affixed to some conspicuous part of the court house. The court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. A statement in writing by the court issuing the proclamation to the effect that the proclamation was duly published on a specified day in the manner specified in clause 1 of subsection 2 shall be conclusive evidence that the requirements of this section have been complied with and that the proclamation was published on such day. Where a proclamation published under subsection 1 is in respect of a person accused of an offence punishable under section 302, 304, 364, 367, 382, 392, 393, 394, 395, 396, 397, 398, 399, 400, 402, 436, 449, 459 or 460 of the Indian Penal Code 45 or 1860, and such person fails to appear at the specified place and time required by the proclamation, the court may, after making such inquiry as it thinks fit, pronounce him a proclaimed offender and make a declaration to that effect. The provisions of subsections 2 and 3 shall apply to a declaration made by the court under subsection 4 as they apply to the proclamation published under subsection 1. Other rules regarding processes. Issue of warrant in lieu of or in addition to summons. A court may, in any case in which it is empowered by this code to issue a summons for the appearance of any person, issue, after recording its reasons in writing, a warrant for his arrest. If either before the issue of such summons or after the issue of the same, but before the time fixed for the appearance, the court sees reason to believe that he has absconded or will not obey the summons, or if at such time he fails to appear and the summons is proved to have been duly served in time to admit of his appearing in accordance therewith, and no reasonable excuse is offered for such failure. Arrest on breach of bond for appearance. When any person who is bound by any bond taken under this code to appear before a court does not appear, the officer presiding in such court may issue a warrant directing that such person be arrested and produced before him. A bare perusal of the above said provisions makes it clear that under these provisions of CRPC, a police officer has almost omnipresent power to arrest. He can arrest a person even on having a suspicion that such person has committed a cognizable offense. Although in certain circumstances the police officer is required to record reasons for arresting a person or is required to have a satisfaction qua the necessity of arrest. However, all these requirements are intrinsic to the arresting officer. These requirements do not create any external or outside hurdle for removal of which the assistance of a court or magistrate may be required. Hence, if a police officer has some valid reasons to arrest a person, he has as wide powers to arrest a person without warrant as it could have been. He has an authority of hot pursuit as well if the person sought to be arrested happens to have moved out of the territorial jurisdiction of such police officer. Not only that, the police officer also has the power to enter into a premises if the need arises and to conduct any search and seizure. Even in those cases where the warrant from a court or magistrate may be necessary, an exception has been carved out for the said police officer, that is, if obtaining warrant from court would create a scope for the offender to flee, the police officer can arrest a person even by entering any premises and conducting a search and seizure there. Therefore, for the purpose of arresting a person during investigation of a case, a police officer has all pervasive powers without requiring any assistance from the court or the magistrate. The only limiting factor created by law is that in certain situations he is required to record reasons for arrest and in certain other cases required to have reasons to believe qua involvement of the person in the cognizable offense, even though not required to record reasons as such. Still, further, in certain cases, a police officer can arrest a person only if he has reasons to have suspicion over such a person qua certain aspects. Hence, the crux of the limiting factors for the power of arrest without warrant of a police officer. Stop.